first introduce our panel devoted to personalized law. I think we will have a lot of very interesting discussions. Firstly, Professor Cavey, you are Professor of Law at the University of Chicago. You are an expert on bankruptcy and on the law of business and finance. I've noted you've made many researches which examine the intersection of finance and law. You also wrote about the role of intellectual property law in the organization and financing of creative projects and how technological innovation is changing the foundations of our legal system. I'm sure we will have the opportunity to deal with that this afternoon. Secondly, Professor Restrego Amariles, you are Professor of Law at HEC. I haven't found any English translation. You're interested in private international law and contract law and common law. If I resume, you're also a lawyer admitted to the Colombian bar, and you've been involved in multilateral working, especially with United Nations. And you have a specific interest regarding international trade, its rule and regulation, and also about smart law, but I think you will have some opportunity we will have many things to learn from you. And lastly, Professor Ariel Porat, you are Professor of Law at the Tel Aviv University and a visiting Professor of Law at the University of Chicago. You have also been a visiting professor to the universities of Berkeley, Columbia, New York, and Virginia. And you are a member of the Israel Academy of Sciences. And you were also the winner of the Emmett Prize for the Art Sciences Culture in 2014, and you also are the author of many books, in particular Tort Liability Under Uncertainty and Getting Incentives Right. Just try to check some elements of your biography, but if I've forgotten something, please feel free to say it. Let's now start for your presentations and discussion. We will begin with Professor Anthony Casey. I had the opportunity to listen to your talk devoted to the short, happy life of rules and standards, but you will talk this afternoon about the end of rules and standards, so we are listening to you.
Thank you. Yeah, so let me start. So the idea is the end of rules and standards. And what I'm going to be talking about is slightly different from what we've heard and about to hear, less about the substance that, the substantive changes that artificial intelligence, big data, predictive analytics are going to bring, and more about the form change to law. And what I'm going to suggest is that big data and predictive analytics are going to change the form of law in a way that is transformative and really arguably more important than some of the substantive things. And as an analogy, you can think about Uber and Airbnb, right? So the substance of how you use paid transportation or hotels is kind of the same. But the form is dramatically changed, and we can see that it's changing the economy quite a lot. And I think with law, we're going to see something similar. And the institutional implications are going to be huge. All right, so what do I mean by changing the form? Well, I mean that the traditional legal debate is laws have been written either as rules or standards, and I suggest that that's going to go away. That distinction will no longer exist as we get to the point where, as we saw today, maybe this is far down the road, but where judges can be replaced by machines or laws can be written by machines, and that brings the end of rules and standards and something new. All right, so I'm going to explain what that means, and I'm going to go through it with an analogy. I'm going to use driving laws for two reasons. One is it's kind of easy to get our mind around, but also it'll allow some insights into the way things progress, and I'll cover that near the end. All right, so what is going to replace rules and standards? Something I'm going to call a micro-directive. A micro-directive is a law that the legislature writes something very vague, and it's their objective, what they want the law to achieve, and a machine can translate it into a specific order to a citizen at the moment the citizen needs that. So it's a personalized law that achieves the objective that the legislature wants, but it's written very vaguely by the legislature, but it comes very specifically to the citizen. And how do we get there? Well, big data, predictive analytics, artificial intelligence, the stuff we heard about this morning, are going to provide predictions of behavior and outcomes that allow for these laws to be very specific, to say, in this situation, we want the citizen to do this. In this situation, we want them to do this, rather than we just want them to act reasonably or some general rule that may get it right or wrong. Now, that doesn't work on its own. You actually have to communicate it. So I'll add to the technologies we've heard about communication technology. And this runs two ways. So we can observe the data in the world that tells us which situation someone is in, and then we can communicate the analytics that tell them how they should behave in a specific situation. And that's what I call a micro-directive. And as the next few slides will make clear, it will replace the form of rule, the choice of rule or standard. Now, one thing I should pause to note, and this goes to what we heard right before the break, I've used as my assumption that predictive analytics will tell us what outcome we want, or tell us what behavior we need to get to the outcome we want. That is the idea of using analytics to predict certain outcomes. I could replace this and do the other version we heard about and say, we could just have the computers predict what a judge would say we want you to do, which is one level removed from that. Either way works, and you can use the analytics to get you there, whether it's predicting the outcome you want or what a judge will say the behavior you want is. And those are two different things, and whether or not we use the technology to one or the other is important, but we can use it to do either one, and I'll come back to that. All right, so what do I mean by all of this? I think the traffic law example will help me explain. So generally, this is a rule. Drive 60 kilometers or miles per hour, depending on which system of measuring you use. That's a rule. If you go over that, you're speeding. If you go under that, you're fine. You could instead have a standard and say drive reasonably. Generally, people talk about the trade-off that this choice brings. So the drive 60, the rule, has the benefit of giving certainty to the driver. They know what the law is. They know that they're not breaking it if they're going 59 miles an hour. However, it doesn't get things quite right in every situation. If it's pouring rain or hail, driving 59 might be really unsafe. If it's sunny and no one's on the road, driving 61 might be fine, but the rule says, no, this is a clear cutoff. Drive reasonably, on the other hand, lets the judge applying it take into account all the actual things that happen and say, yeah, I know the person was going 61, but there was no one else on the road and it was completely sunny, it's okay. Or, yes, I know you were going 50, but it was pouring down rain, that was really dangerous. Now, you can make a rule better by making it more specific, so you can do something like this and have a rule that says 130 in the sunshine, 80 in the rain, but as soon as you try to introduce enough specific instances, you'd have a sign that covers the whole road, right? So you'd be drive this for this and this for this. It'd be incomprehensible to the driver. So we can't have rules that look like that, which is why you might choose a standard. Ideally, you would have a rule that looked like this. For you, a 32-year-old with 12 years of driving experience, driving that VW on this rainy day, on this highway, and it's a Tuesday, you should go 51.2 miles an hour. That would be great, but in the current system, we can't do that for two reasons. One, we can't communicate that information to the driver, and two, we don't have the predictive analytics to know that it's exactly 51.2 in those situations. But that's where things are changing, and that's where analytics and big data make things different. We can actually have this law, and if you don't think that that's possible, just imagine what we're doing with self-driving cars. A self-driving car has a computer in it that's telling it exactly that. Now, it doesn't have to take into account who the driver is, but it's saying on that road, given all the data you're taking in, drive that car at this speed. Now, it's also taking into account the speed limit, but if you said create the speed limit, it could then spit out 51.2. And so we could have a world where the lawmakers say, we want drive reasonably to be our standard. That's what we're trying to get at. And then an administrative agency says, okay, instead of saying 60, I'm going to say, computer, spit out whatever the right speed should be, and do it on the dashboard of the car while they're driving. And that's what I refer to as the micro-directive. And the reason I say it's not a standard, it's not a rule, because from the lawmaker's point of view, they will state the global objective they want. We want people to drive reasonably, and that will define what that means. They don't have to come up with a specific rule for any specific situation. But from the driver's perspective, they never see that drive reasonably. They see drive 51.2 on this day at this moment. And so as analytics improve and as big data gets more information from the world and communication can gather more kind of observations about what a person's situation person's in at a given moment, as that gets better, we can do this not just for speeding, we can do it for regulation of tax paying, we can do it for managing, for negligence in surgeries, and you'll hear Ariel talk about that with kind of setting levels of negligence in performance and professional guidelines. We can do this in all kinds of areas, and it changes the way laws are written. They get written in this micro-directive form rather than in the rule of standards form. And so if you think about it, this is the way law looks with a standard. You have the standard, you have the regulated, it's cutting off the bottom there, it should say regulated action, and then content is provided by the judge, the police officer enforcing the law. Someone is providing the content after the fact. That's what a standard does. It allows you to take into account all the situations and all the facts going on when the regulated action took place, and then apply the content of the law to those facts. A rule just flips it. The content of the law comes at the very beginning. You then have the regulated action. All the court has to do is verify what the situation was and whether or not people complied with the rule. The micro-directive looks something like this. Again, it's cutting off the bottom. You have the micro-directive passed. That's the we want people to drive reasonably. The computer, the data is being processed. At the moment you're about to take the regulated action, it spits out the content of the law. And then the judge just verifies that the data was correct. And that's all that's going on with the micro-directive. Now, I can actually give you an example of a very primitive micro-directive from the traffic law that we don't think of as a micro-directive, but really demonstrates what it is. So in traffic, this is a stop sign. This is a rule. It's over-inclusive because people stop at a stop sign when no one's on the road. But they know that that's how they can comply with the law. This is a standard. A yield sign says stop if reasonable. And the laws are written such that the judge has to decide after the fact whether or not it was reasonable for you to stop or not stop, given the yield sign and all the facts around you. What does a micro-directive look like? It looks like this. This is a signal that says, we will tell you, the driver, to go or to stop at any given moment when you are on the road. Now, you might think, wait a second, that's a rule, because that's the way drivers think of it. The consumer of the law sees green, yellow, red. The producer of the law, if they really were writing the law as it is on the books, would write something like this for a very primitive stoplight. So given a time interval of 30 seconds, you're going to stop when it's red, you're going to go when it's green, so we want people stopping from 0 to 30 and going otherwise. But as stoplights have gotten better and been able to observe data on the road, you could say something like this, where we want you to stop in the intervals of time, unless there's no cars coming from the other direction, then it's going to turn green. That's the way the law looks, and so this becomes a pretty specific algorithm that gives you the rule. The driver is still seeing green or red. You can add to it if, in the bottom it says baby emergency, if you can sense from your sensors that someone has an emergency, we're going to turn the light green for them and red for everyone else. You can add all kinds of other factors, and it can start to look like this. And when you get to kind of neural nets and big data and learning algorithms, you can just say, we want people to minimize accidents, and minimize traffic delays. That's what the producers of the law write. This is what the consumers of the law see. And certain cities have already started to use smart traffic light systems that are intended to do exactly that. And so the legislators just state their goal, the programmers program a system that then implements that, and the driver sees green or red. And the idea is you can do this for much more areas of law, such that the law is green or red. The producer says, well, I'm going to write a standard. And so this is the idea of the micro-directive. And so what does this all mean? Well, traditionally, when we think about rules and standards, we're thinking about who do we want to create the law? If we use a standard, we're letting the judges or people after the fact create the law. If we use a rule, we're having the legislature create the law. And then we want to ask when we want to reveal the content of the law. But if we go to micro-directives, those first two questions go away. The micro-directive doesn't give you the choice of who's going to write the law when you decide between rule or standard. The lawmakers pass a standard, the computer implements it, the lawmakers have written the law, the judge doesn't do anything. So you actually have a world where the judges aren't putting into place their own views of the law. So this goes back to what we heard this morning. They're less important. They have less of an impact if we have a micro-directive in place. We do have to decide when we reveal the content of the law. So you might want the person not to know the law until after they act. You might do that for tax evasion purposes in certain areas. But we really want to ask, how do we set that social objective? And this should worry us if we don't think about it, because setting the social objective comes from whoever writes the algorithm. And you could imagine, this is the second reason I use driving, you could imagine the algorithms popping up not from the lawmakers, but inadvertently from the private market. So we might soon end up in a world where all of our traffic laws are written by Google and Tesla, because they're the ones programming cars and competing. And then the judges, thinking they're applying a standard, say something like, as long as you have the Google software in your car, you're complying with reasonable behavior. Well, what does that mean? It means the judge just in that one ruling decided that Google has written the traffic laws. And so the private market then is the one writing the law if it develops that way. Or the law could develop by writing an algorithm that mimics what judges do, and then you get all of the problems of bias of past judges being implemented into the system. Or the lawmakers can say, we're going to start anew and write a standard and then write our own software. Or they could just write a standard and then all of a sudden the agencies use software. And so all of this suggests that if you kind of don't pay attention to the evolution of the micro-directive, the source of law and social objective can come from somewhere you're not predicting. And so we want to be very conscious of this. So the questions we really need to know is, how do we decide who makes the law? Do we want it to be the legislature writing the social objective? Do we want it to be a judge blessing the private market's version of what the law is? How do we want it to be administrative agencies implementing it? And in that world, then the question is, what role do the judges and lawyers have? So at least in the US, people think of judges only get to see a case when there's a case or controversy. But they then can put in their view of what the law should be in every case and controversy. There won't be as many cases and controversies with a micro-directive. So if you want the judges to second-guess the legislature, you need to let them give advisory opinions. You need to change their role and say, well, now we need different institutional mechanisms to question whether or not our social objectives are proper or improper. And that becomes one of the main questions that big data and analytics will bring for law is, who's deciding? Who's setting the rules? Just like with Uber, who decides what a safe ride is? Right? We had taxi regulation companies, and all of a sudden we don't. And these are the questions that are really important for the future of law in a world of big data analytics. And as I've kind of alluded to throughout, we need to decide what are the different paths that get us there. And the private market path and the public market path are very different paths, and they will set up very different institutions. And so these are the questions, I think, that really face us in the kind of coming advances of big data for law is, we can worry about the substance when we're programming the algorithm, but we have to worry about who's programming the algorithm first. And that is the most important thing, and that's why I think the death of rules and standards is this institutional question that has to come first in thinking about the future of law in this context. All right, that's it. Thank you.